Good morning, Your Honors. May it please the Court, Ben Cuney. I represent Joseph Keeler, whose conviction of murdering his wife of 20 years led to his conviction and sentence of life imprisonment. I ask 4 minutes for rebuttal. The case itself on appeal presents a combination of evidentiary insufficiency and a claim that the prosecutor's closing argument was essentially way over the top based on a totality of circumstances, unduly persuading the jury based on inadequate evidence of perpetrator. The single issue in this trial was, did Joseph Keeler do it? Was he the murderer? The closing argument set the stage for pushing the jury to disregard the evidence and the lack thereof and to ultimately reach a verdict that is not sustained on the evidence. The fundamental concern with the closing argument is that it presents a total miscarriage of justice, which is the standard this court is going to have to utilize because the defense counsel did not pose objections to the repeated improper prosecutorial comments that come into 5 categories, all of which push not just the limits of the evidence, but essentially create evidence that did not exist in the course of the trial. The first of which is the misrepresentation of DNA evidence. The evidence of DNA could be, probably is the marker of the perpetrator. The evidence of DNA underneath the victim, the wife's fingernails, clippings taken, testimony, defensive wounds, the wife was fighting off the attacker. Knife slashes caused the death. The DNA scraped from her fingernails shows, 1, her own DNA, standard, reason for that. Second, DNA of an unknown person who is not Joseph Keeler.
It shows human DNA from one locus of
Correct.
DNA from which no human being can be identified. Right?
Correct. Unknown DNA, and the locus, as the court says, father, mother side, not sufficient to make a match, but sufficient to scientifically exclude Mr. Keeler. DNA evidence underneath the fingernails, not Mr. Keeler.
It excludes him from being the source of one tiny portion of DNA underneath a fingernail, apparently. How does that exclude him from the crime?
Two things, Judge. First, in this issue, we're kind of moving to the insufficiency issue, and the insufficiency issue is a combination of items. The fact that somebody else's DNA is found underneath the fingernails is certainly probative of something, whether it's probative.
Let me ask a question
Yes, sir.
specifically on that, because the expert witness was very careful in her testimony, and what she said was that this additional locus was potentially an additional contributor. And I think read in context, it suggests, as you do, there was somebody else that potentially was there. But nobody asks the question, and maybe it's inferred, but nobody asks the question, could that DNA be the victim's DNA, because we only have this one loci. Nobody asks that question. So is it possible to read this and understand that in fact there was another contributor, or do we take her words literally that, well, potentially there's an additional contributor?
Transcript 745, 746. Expert Wentworth, I believe, is the expert that Your Honor is referring to. Testifies without ambiguity. There is DNA that belongs to Mrs. Keeler. So that's the known Mrs. Keeler. The unknown DNA, she says, it's unknown, it can't have belonged to Mr. Keeler, and it's from somebody else.
Potentially from somebody else. I mean, her words are potentially an additional contributor. And that's what I'm trying to get a handle on. Am I reading too much into the potential part of this?
Transcript 745, and I believe Your Honor is, the right fingernail clippings contain the victim's DNA and an unknown DNA, not Keeler's. Not the victim's, not Keeler's, meaning Mr. Keeler. The reason this becomes the issue, and DNA is such compelling evidence in cases, we understand that. The prosecution, in closing, misrepresented, we say, totally recast the evidence by saying, arguing contrary to any evidence that there was not somebody else's DNA underneath there. That's quote, page 852. That is false. It's not consistent with the testimony, and it's not even a reasonable inference from that testimony.
No one testified that there was any other human being who could be scientifically identified at all from what was underneath her fingernails other than her. Isn't that correct? I mean,
No, Your Honor.
I mean, this may be a mild overstatement of it, but I don't see this as being a blatant misrepresentation of the evidence.
The testimony of Wentworth. 2 human DNAs were found underneath the fingernails.
No.
Yes.
DNA from one locus. Admittedly, that is human DNA, but it's not enough to identify anyone and excludes large numbers of people. But I mean, it's one. You have to have about 17 before this stuff works.
Absolutely, Judge. And the statement by the prosecutor, there wasn't
So
somebody.
he's supposed to say that it didn't identify anyone except for this one little piece that could have come from a billion people that she picked up in her dirty house.
Well, that's possible, Judge. And certainly the
it's
statement that
fundamental error
says.
to do this, to say what was said.
Pardon, Judge?
This is something that the defense lawyer can't address in closing argument. I mean,
Well, the defense lawyer did not object to this. The defense lawyer got it wrong, as my brief points out, with regard to what the DNA evidence was.
in this case, the DNA evidence is never ever going to prove who did it, and it actually is never ever going to prove that Mr. Keeler didn't do it. He lives with her, so you would actually expect to find some DNA on and about her person because of that fact.
Well, absolutely, as DNA was found in the sink, not necessarily connected to the murder, but because the witnesses said he uses the sink. But the underneath the fingernails is the precise issue, and had the prosecutor said, we don't know who else's evidence DNA is, that would be accurate. But to say nobody else's DNA was found, that's flat out wrong, because somebody else's DNA was found. They may not be able to type it, but they can certainly exclude it. That leads to, and that's a material misrepresentation in this case.
You're arguing fundamental error. This would have to be something that is so significant that it deprives your client of a due process, of a fair trial.
Yes, sir.
And if DNA is never going to prove who did or didn't do this crime, how can this be fundamental error?
Well, it does 2 things. For the jury to be told nobody else's DNA is there excludes anybody else as having been a person who the victim would have been fighting off. That's number 1. And number 2, and there is no explanation for this, Your Honor. Mr. Brennan, the neighbor who was at the house, no testimony whatsoever of his typing, not typing, etc. That's an absence of evidence. No explanation in this record as to why Mr. Brennan did not have DNA tested or anything of the sort. We understand from the context of the case, but it's only a reasonable construction that the police had identified Mr. Keeler as the perpetrator, so no further investigation happened. But there is somebody whose lack of exclusion could have easily raised a reasonable doubt, and that person was effectively excluded by the prosecutor's misstatement. That leads to another issue in closing, the comment on silence. Pre-Miranda, pre-arrest silence. Not admissible, not usable. Mr. Keeler did not testify at trial, so it can't be used to impeach his testimony at trial. And clearly the silence, 20 minutes of silence, was reasonably susceptible of being a comment on the silence. The prosecutor ran roughshod with that in closing. Again, no explanation, no objection by the defense counsel, but the prosecutor said the defendant, Mr. Keeler, didn't give an explanation. He didn't say, I didn't kill my wife. He was silent when confronted. And that is...
Wasn't that, however, in response to an argument that he was cooperative with law enforcement? How do you...
Yes, Judge LaRose. The state argues in its brief that the defense counsel, in closing, commented about cooperation. The clear context and juxtaposition between what the prosecutor said and what the defense lawyer said is the defense lawyer commented on the first agreement to go to the police station. Before Mr. Keeler agreed to go to the police station, he was cooperative, and he agreed to go to the police station. The comment that the prosecutor talks about is the police interrogation. No, not interrogation, because Mr. Keeler was not in custody, but still under the case law, pre-Miranda, pre-arrest silence is, and by the way, Mr. Keeler was told, you don't have to answer any of our questions. Not a Miranda, but you don't have to answer any of our questions. That silence was in response to accusatory questions, not the cooperation that led to Mr. Keeler going to the police station. So completely different context, and the jury could not have misunderstood what that is a response to. The third item is excluding motive as being totally irrelevant, yet the case law, fundamental case law, says in a circumstantial evidence case, the lack of motive is a factor, is a consideration in establishing the culpability of the defendant, not irrelevant. Essentially, that put an additional burden on the defense to prove that there was no motive by the prosecution's argument. And then the last one that we raise as a significant issue is essentially branding Mr. Keeler as a liar. Mr. Keeler as a liar, not from his referring to the jury by pointing out to the jury whether he did or didn't do something, but by his responses to police questioning. That lie, which was not a lie, dealt with his statement to the police about where Brennan, the neighbor, was when he first met him. Prosecution argued, oh, Mr. Keeler was coming out of his house as he met Brennan. Brennan says, no, that's not the case. We met on the sidewalk on, I believe it was 4th Street. Transcript page 861, Brennan says Keeler was not near the trailer when they met. They were on 4th Street. By calling Keeler a liar, Keeler, who did not testify for the defense, the prosecution in cumulation raised too many confrontational, fundamental errors that led to a miscarriage of justice, which propelled, in count 2, those totality of comments, propelled the jury to conclude if there was nobody else who left DNA underneath those fingernails, if there was nobody else, Brennan hasn't been identified in any way, then Mr. Keeler must be the culprit, must be the perpetrator, even though the evidence of Mr. Keeler's involvement in this crime is non-existent. His alibi defense. Imperfect alibi, no doubt about it, imperfect alibi, but no testimony that he was present at the time the murder took place. No physical evidence connecting Mr. Keeler to the murders. No motive. Prosecutor said it was irrelevant, but no motive. Marriage of 20 years, not a single bit of evidence suggesting anything untoward in the course of that time. And the manager from the trailer park said no prior instances of any kind of violence or misconduct between the two. And somebody else's DNA found underneath, some unknown person's DNA found underneath the fingernails. For all those reasons, we ask the court to vacate the conviction, murder in the first degree based on insufficient evidence, and discharge Mr. Keeler, or alternatively, because the press based on the prosecutor's overreaching led to reversible error, we ask the court to reverse the case and remand for a fair trial. Thank you.
Thank you. I congratulate you as compared to the last case in using precisely 16 minutes.
Perfect.
May it please the court, Cerise Taylor on behalf of the state of Florida. Your Honor, this is a fundamental error case, as the court already reflected. Starting with the DNA evidence, Judge Silverman, the inference to be drawn from the DNA testimony, the state believes, is that that evidence did not reflect someone else's involvement. There was no conclusive evidence. There was no really suggestion. There was the one loci. And I think what's important to note is that in closing argument, even the defense interprets Ms. Wentworth's testimony as reflective of there not being DNA present from another source. What they argue is they say, none of my client's DNA was found under her fingernails. I don't think anybody else's was. And that is in defense closing argument. And then we have the state's rebuttal talking about, again.
The expert's testimony. I don't think Mr. Cuny has misread it, but the expert says in a couple of different places the same thing in different ways. At one point she says potentially there's an additional contributor. At another point, her testimony can be read as suggesting that in fact there is some mysterious unknown person's DNA in there.
Right.
But nobody asked the question, could that DNA be the victim's, or in fact is it indicative of a third party? So is there anything you can say to elucidate on that?
No, you know, I mean, I think this is testimony that is the kind of testimony that's perfect for a jury to consider because it is subject to interpretation. Ms. Wentworth's testimony starts out with the inconclusiveness of this evidence, and then she goes on to mention the one loci. And so I don't think that this testimony establishes that there was other DNA, and she wasn't scientifically able to say there was other DNA under this.
It's not the victim's DNA, because apparently this is a
Right.
locus that the victim
Right,
doesn't
it's one
possess.
loci from some, you know, you have some for your father, some from your mother. So she wasn't able to elaborate because she didn't have enough material to elaborate. So the state's position is that this statement from the prosecutor in closing argument was not meant to misrepresent the evidence, was meant to make an argument based on that testimony, which in itself was inconclusive, I would argue. And also, the state's point of view of that evidence was consistent with the defense's point of view of that evidence, was that really it was nothing. There was nothing there. But even if there was some DNA, let's assume for purposes of argument, there was some DNA, the question is, under a fundamental error standard, as Judge Altenburn pointed out, is that enough to get us to fundamental error relief? And the answer is no, because of all the other evidence that we have in this case, and additionally because there's no question that the victim in this case did receive visits from hospice, and that she did leave the home. She wasn't incapacitated in the bed all the time, and so she would have had a connection to other people in the community. She was using the communal laundry area to do their laundry, and so it's not unlikely that she could have picked up some DNA somewhere. The reference to the state of the house, although the evidence does not say, I would argue, suggests that the state of their personal hygiene might have been similar. And so perhaps she didn't have the world's cleanest hands. We don't know. But what we do know is that she had potential access to other people from whom the DNA could have been sourced if the court believes that there was DNA. And the state believes that this argument that there wasn't any evidence to support someone else's DNA is a fair argument based on the evidence that was presented.
Well, Mr. Cuny's argument, and the quote from the state is, the point is there wasn't somebody else's DNA underneath there.
Right.
And that isn't fully accurate.
Well, you know,
Then there's also the statement that is on another issue, but it has to do with his silence.
right.
Where the state argues, and his not giving an explanation is a huge admission in this case.
With the court's permission, I'd like to look at them separately. The reason that I referenced the defense argument in closing argument was because it was identical to what the state argued, that there wasn't evidence of someone else's fingernails. And so rather than whether or not it is entirely accurate based on the scientific testimony, and I would argue that the scientific testimony itself was equivocal, it's a fair argument based on the evidence, and it didn't rise to the level of fundamental error. So even if the court believes that the prosecutor, whose belief was consistent with the defense counsel's belief, was incorrect, and in addition overstepped its bounds in making that argument, so for the court to find both of those things, for relief to be entitlement to the appellant, you'd have to further find that two steps, there was a third step, and that was overreaching to the point that it deprived the appellant of due process, and we don't believe that this evidence shows that. With regard to the statement about silence, their argument is that it's reflective of his invocation of his right to remain silent. Throughout this case, even at trial, Mr. Keeler presented this figure, and this goes to the other issue about him being a pathetic figure, this silence, this sort of catatonic state that they talk about with regard to him. What the state was trying to argue in that was not that he was invoking his constitutional rights. What the state was trying to prove was they argue that he was cooperative. And with all due respect to the appellant's argument, when I look at the closing argument and the defense is talking about the cooperativeness of the client, what I see them saying is that he was cooperative, he answered their questions. And so really it's not just in that he agreed to come along, that he...
And to that point, I think the argument is fine by the state. But then they shift to what it is he refuses to tell us, and he refuses to explain. And so he can't explain his clothes, and he can't explain why he was sweaty or not sweaty, and he can't, the litany of things that he hasn't done. And that at least has the flavor of a Fifth Amendment problem for you.
You know what, Your Honor? I think that what's key to this case is the fact that it's rebuttal. And I think that the courts, again, taking a look at defense closing argument, the court will see that those are the kinds of words and phrases and language that the defense is actually using. The defense talks about, he says here, then the problem started arising once Mr. Keeler was let go the first time. Wandered around all night, stayed up all night, then called the detective like he said he would. But where are the clothes? Well, Mr. Keeler either can't or doesn't answer, doesn't say a thing. And then there's a later point where he makes a similar argument. He says, what the state is trying to do here is commit Mr. Keeler off of first-degree murder because he just can't explain where he was. That's what it is. Or he won't tell them or can't tell them where the blue polo shirt and the khaki pants are. Well, that doesn't mean he killed anybody. And so these are the kind of comments in closing argument that the state is rebutting and making fair comment on in its closing argument. And of course we have to consider that the state's evidence includes these recordings of these interviews with police, where the jury's able to see he's not talking, he's catatonic, he's staring into space. They see the first Mr. Keeler, the pre-gotcha of the evidence that he changed his clothes, is discussing what he did, and he went to the interviews and he left home and he's giving time, and there's even a point where he talks about his clothing and they say, is that the clothes you were wearing? Yep, down to the jacket. This is the same jacket even.
Are those videos in our record?
I don't know. Do you know? I'm sorry. If the court would like to see them, I'm sure we can arrange for them to be supplemented.
I wasn't sure whether they were or weren't.
But they do, the flavor of them is captured because what we have later on is you have him, this is my clothes, this is what I was doing, here are my business cards that I obtained from these different people. So he's letting them, he's communicating with them. Then, as the investigation is unfolding and they meet with him and they say, we've got these videos and this is not the same clothing, then we see him shut down. And that's what they're talking about. They're not talking about invoking a constitutional right. They're talking about a paradigm shift, a change in his demeanor, a change in his behavior, and that change is reflected in the recorded interviews. And so we see the police saying, listen, are you still participating here? You don't have to stay, but if you're not going to talk to us, you need to go. You know, holding the door to say, this is either we're done or we're not done. What are we doing here? And so he does visibly remain silent. He does visibly withdraw. And that's what they're talking about when they say on rebuttal that sure, he was communicative then when his story, his concocted story, was plausible. But as we developed evidence from the video surveillance cameras that were on these businesses that he went to interview, that showed he had changed his clothes, then key points of his story, where he was and when, you know, what he was wearing and the timing of his leaving the house, starts to fall apart.
Was there any objection by the defense to the videos coming in?
I don't believe that there was an objection. I know they were shortened a little bit, and there was one irrelevant.
There was some redaction, and
Yes.
my recollection is at one point the defense actually stipulates to them being admitted.
I'm sorry, I don't exactly recall, but I don't remember it being an issue. And the thing is that.
Well, there's no issue on appeal as to that.
Correct.
Anyway, I mean, the real issue is, was the rebuttal argument crossing the line?
Right, exactly, Your Honor. And based on the context of what the jury saw, defense counsel, they would lose credibility if they tried to say he was gregarious and outgoing the whole entire time, and then they showed a video where he was withdrawn. Also, they had the client in the courtroom to deal with, and the record does reflect this sort of catatonic, withdrawn behavior. And to the point that the court references it, and what should we do, what should we tell the jury? He wouldn't dress out, he looked kind of disheveled. They decided to tell the jury nothing, but at the end, they're compelled to say, you know, he presents this pathetic character, meaning pitiable, and that this is not something that you should consider. You, the jury, have sworn to decide on the evidence, and that is what the prosecutor was asking the jury to do, to stay to its oath. And so we believe that these statements, taken individually, taken together, they are reflective of the character of the closing argument from the defense and of the evidence that was presented. And so they were not an attempt to misrepresent to the jury, mislead the jury, or to obtain the jury's sympathies for the state's case.
What about the discussion of motive, which comes in rebuttal and doesn't really seem to be particularly responsive to the defense argument? And this is pretty muchly a circumstantial evidence case when it comes down to who did it.
Right.
And so motive is normally a fairly important thing for the state to use in one of these cases.
Well, I mean, you know, again, technically the state, of course, does not have to establish motive, and so the state is correct making that observation. But I think where motive comes in the defense's position is, obviously the defense was, it was not me, it was somebody else. And so that defense of it was somebody else implicitly suggests that it was for some gain. That maybe I think they even argue that someone might have seen Mr. Keeler leave and then, not knowing that Mrs. Keeler was in the house, snuck in, and they either say it or the clear import of it is, you know, to obtain something illegally, to commit a theft or something like that. And lo and behold, they encounter Miss Keeler and the murder occurs. And so that's their hypothesis of innocence, that somebody else did it. And the motivation underlying it would have been theft. Or, you know, you could even maybe imagine attacking, if they knew Miss Keeler was there, attacking Miss Keeler. And so to the degree that the state is arguing in rebuttal, you know, don't get distracted with this whole motive thing, because that's not what we are required to prove. We're not required to establish.
The difficulty is, during the statement, what the state says, talks about motive, and then says, and because motive is an operation of the mind, just like intent is. That is irrelevant to you folks sitting here today. And I did leave one sentence out. You can't always prove how a person is thinking or why they did it. And then he says that's irrelevant.
I think in that context, what the state is saying is that this is not something that is subject to proof. All we can do as the state is establish the elements that we're able to prove. We're not able to directly prove intent, as everybody knows. That is an operation of the mind, and so it would be for the jury to decide.
But you agree your intent is not irrelevant. This is a first-degree murder case.
I don't think I can stand up here and say that intent is not irrelevant. But nor would I try to mislead the court by suggesting it, but I do think that intent is not something we can establish. It's not something, all we can ever have is an inference of intent, and that really underlies all of the level of cases talking about the circumstantial evidence, wholly circumstantial evidence cases, that we can't ever prove it.
Well, it's clear from other parts of both the case and the arguments that are made that the state argues intent is shown because they talk about premeditation. So is this simply a slip of the tongue that doesn't rise to fundamental error? I mean, you didn't really argue it to any great degree in your brief, so here's your chance to tell me why this isn't fundamental error.
Yeah, I guess as I'm standing here thinking about it, really, it almost is like intent we're in two separate hats here. With regard to arguing with premeditation, the state is saying that we've established a burden of premeditation because we've shown the multiple cuts and the level to which the penetration of the neck and the skull fracture, and then it kept going with the brutality. So it almost is like that is segregated from the question of intent that is being raised in rebuttal to their suggestion that there has to be motive. And so to the degree that it comes up in that context, I think that's why the state is saying it's irrelevant, meaning that we don't have to prove he did it because he got sick of her. He did it because there were divorce papers or some reference to divorce papers. So that's when we're talking about intent and rebuttal. I really think that's what they're talking about. We don't have to show the because. It doesn't matter why he did it. It just matters that he intentionally did it with regard to the premeditation. So I think they're separate. I think and maybe that's a source of confusion. But it doesn't mean that the state is trying to mislead the jury that they don't have to find premeditation, which of course they needed to establish that it was more, every time he did something that was harming the body, that he was killing her, that those multiple cuts rose to the level of premeditation. So I don't think the state is saying that's not important. And I don't think they argued it there, and I'm not saying it here. But when it comes to their rebuttal of the idea of why he did it, I think the state's saying, we can't tell you, we don't know, and you can only be the jury and decide if you think that this evidence proves guilt. So I don't think intent, that we're not saying intent is irrelevant, but in that context, what he's talking about is really more expressly motive. Does that answer your question? Does that make sense?
I understand what you're arguing.
Right. Thank you. Okay. Then with regard to, just quickly, with regard to the evidence, the JOA argument, obviously we argued that it was a boilerplate JOA, but just substantively, what we have here is there's no evidence of a forced entry, there's no evidence of theft, there's no evidence of sexual assault on the body. He's there at the time. His window of leaving is, 1:30 and 3. The ME puts the death at between 10 and 2. He's there. He lies about coming back. He's seen by the manager of the trailer park at 6:30 and 7 in the morning. He lies about those being the same clothes. We can't find the clothes he was wearing. All of those factors establish the state's prima facie case and were sufficient to send this question to the jury. We believe that based on this evidence that the question was sent to the jury properly, that the court correctly denied the judgment of acquittal motion, and that this evidence of the statements of prosecution during the closing argument were reflective of the evidence that was presented at trial and of defense counsel's closing argument, and that they do not provide a basis for appellate relief. Unless the court has any further questions, we ask that the conviction and sentence be affirmed.
Okay. Thank you. Mr. Gunny?
Allow me to address 4 items raised during the state's presentation. First, again, I point out to the court pages 745 and 746 of the transcript. Ms. Wentworth. A mixture of Rita Keeler's DNA as well as that of another person. Page 745, 746. Human DNA, not Mr. Keeler's, not Mrs. Keeler's. State misled the jury 100% on this point. That leads to the comment on silence. The context, and the reply brief pointed out the context of what the defense lawyer raised in his closing was, getting to the police car, Mr. Keeler was cooperative. The entirety of the state's position on using the silence came during the police interrogation at the station house. The accusatory portion, when the defendant shut down. It's not usable as substantive evidence. It's not usable to impeach because Mr. Keeler did not testify at trial, and it's not usable to establish any elements. This was burden shifting in the worst possible way. Mr. Keeler had an obligation to tell you jurors whether he killed his wife or not, or that he didn't kill his wife. 3, and that's fundamental.
That seems to be a little bit of an overstatement.
Well, yes, but
because the tapes come in, not only is there no objection, they're actually stipulated into evidence. So the jury is getting to see the redacted tapes, and I think one of them was the full tape. The state, just like the defense, is allowed to comment on what's on the tape. The word that I'm concerned about, particularly, is where the state says that it's an admission, that his silence is an admission.
It's an affirmative use of silence to establish an element, changing the burden. Again, this entire aspect, not objected to by the defense, but given the nature of the constitutional issue and the thinness of this evidence, it is fundamental on this case. 3, the motive issue, just like using silence as an element, an admission. The motive, as Judge Silberman points out, is likened to intent, irrelevant. That's a wrong statement of fact. It's a wrong statement of law. It could very well have led the jury to conclude Mr. Keeler has an obligation to tell us that he didn't do it. And finally, the sufficiency of the evidence claim. We do not agree that it was a boilerplate motion for judgment of acquittal in this case, because the only issue was perpetrator, identity, did he do it? That issue was raised, it was preserved, the evidence is too thin to support the verdict. We ask the court to reverse and remand, or reverse for insufficient evidence. Thank you, Your Honor.
Thank you. Well argued by both sides. Mr. Cooney, I take judicial notice that your mother is not in the courtroom today. I hope she's doing all well.
As I pointed out the last time, Your Honor, she passed.
She passed?
Around the time that Judge Silverman's father passed.
All right.
And she used to say that coming to court was really her claim to fame.
Well, we always enjoyed her here, and I'm glad you're continuing to do this pro bono work here in our district. So thank you.
Thank you, Your Honor.
Take a break, and when we come back, we'll pick up with this flip.
About 50 or 100 law students watching, which is...
You got no audience today.
Yeah, I know.
I haven't been here a long time. I did like 3 appeals myself, 2 years of practice. I only got done one since.
That would be the Appellate any day.
That's a better place to be as other than that. So, all three of those times I was in the town. One time I used to work for the police, so he sent me to do the argument, and I guess he did like a Brown deal. But I got sent to do the argument anyway, and so I spoke to her, and she not understanding my argument. I wanted to say that I needed my boss to do it. So that one didn't work out. I didn't feel one of my cases last year. Another lawyer did it. He was on the brief, but she went to the law argument. We published it, and we got it reversed. We barred from the award attorney. So the award code, the title didn't get reversed. Just,
I had like 15 all appeals and not yet had one that got reversed. I mean, either side was the appellate or the appellate. Never had a written opinion. No, not that I.
you can kind of follow me because we got a reversal, sent back to trial, we have a hearing on the amount, we didn't know because there were no findings. Basically, what
You guys
still got
still
something for
yeah.
what we figured it was, so we made a set up before, how much we'll take, make you guys not have to. We were hoping we could get reversed. Get a full reversal.
I wish they gave an indication how long they were going to be. Assistant said, mark my copy of the brief so they didn't get the answer to my brief. And the response was, how come their brief is so much longer than our brief? I said, well, here's our initial brief, and the initial and the answer brief are about the same length. This is the one we sent to you before. So. Rest assured, I did raise a few more arguments.
Why is it longer? It's not always good.
Well, it's funny because I just got the email yesterday. They've actually opened up 2 more slots, 2 more second DCA. They're looking to fill 2 new positions in the second DCA. And I don't know. I went out. There was Judge Watley that retired a couple years ago, and I actually went out with his daughter for a little while during her brief separation from her husband at the time. And oh, it was interesting. I certainly misconceived. I mean, I figured he was going, having to drive from Sarasota to Lakeland every day, and I don't think I realized. I think I figured they have oral arguments every day or something, and it's really it's like they have oral arguments only once a month. I mean, they don't have that many appeals, and then they have this big staff and everything else. And he, I think it was Judge Silverman or somebody that I forgot where he's from, but Watley only came to Lakeland typically only came to Lakeland for oral arguments.
It's so much.
Oh, okay. I forgot there's another judge for.
It's on the second you see it also.
Oh, right. That's right. Yeah, she's a good looking lady. Yeah.
Yeah, she was a trial judge when I started, a circuit judge.
I,
I was trying to keep a few matters in front of her. I don't, Harvey just got elected to the bench, circuit bench.
oh yeah.
I went to law school with her, so
Oh wow.
pretty young. Kim Sharp. She, I'm happy for her, but it's like losing a
Yeah.
partner. Someone I thought would be there with me a long time, but he's down the bench. It's kind of weird. We started moving to law school. We started our first year of law school, our first class. I met her in the first class of law school, so now she's a judge.
So I don't think. I mean, you know, it's funny 'cause there's a reason why a lot of judges are coming to public defenders or state attorney's office. Is, and a lot of them it's a raise. It's a way to continue in the state retirement system too.
That's why I think most of them do it. But
I don't know. I think a lot of judges enjoy it. I think a lot of judges you push them to shove. I mean, you know, it's a, you know, not always a great job. Appellate court judges, I don't know. I think if you're really into, you know, that, you know.
yeah, the academia nature of it. But I just thought, you know, circuit judge, it'd be interesting to a point, but you're stuck in the same place.
Mhm.
We go to depots, we go to hearings, we have that flexibility to move around and do different things. But they don't. They're stuck in their chain. They have different people coming in different cases, and yeah, they get to go home with it every day and not have to worry about lives and bringing in business. And so it has its give and take there, but I don't know. I don't think I'd like it be for me.
Yeah.
Or plus, you know, the pay cut. But
Well, some of the judges too, it's like, you know, I know obviously some judges, we know some judges that work harder than others, and the judges that, you know, work far more than 40 hours a week. And some judges, the same case load, work far less than 40 hours a week. But, you know, I think that, but certain areas too, I just don't think there'd be a lot of fun, especially like county court judge being dealing with pro se people all day long.
well, yeah, in a way though, county court would be the most stress-free because you only make a little bit less than a circuit judge. But you don't have to deal with family law. You don't have to sentence anybody to death.
Right.
I mean, you don't.
Yeah, you're right. Yeah.
There are no big time decisions. You know, you're
Right.
making decisions over less than $15,000. So, you know, you just have like you're not.
There's a judge, county court judge in Sarasota. He was talking about they go to these big judge conventions. He says it's always the county court judges that are partiers.
That's what I mean. It's like they got less stress. They still make that. They make like $5 grand less or something. So not a huge amount.
Right.
And they don't really have to make huge decisions. They're really important to the people, but you know they're not making $1 million decisions or putting anybody to death. So that's why I think that'd be kind of the sweetest gig, be the county court.
My mom was married to she's married to a judge, guy's a judge up in Monroe, Louisiana. And I'm sure being a wife of a judge anywhere has its perks, but up there especially, you know, it seemed like it was like a huge deal. She was like, you know, he was like a queen in the city and stuff. When he passed away, I mean, it was like the president died or something. I mean, there was like all the police forces and everything else were out there, all the dignitaries and everything. It was a big deal, and you know, they got paid. You know, it was pretty good compared to a lot of other things.
To the general public, it's a very prestigious. It is a prestigious arm of profession. The general public.
Yeah.
So it still has that mystique and that.
I think too, you have to you have to live a completely separate life too. I remember I was done. The Kings one time, there was just 3 judges that were just these 3 guys. I didn't even know they were like out some people knew them. They were all partying. They were just, you know, having time there, and they were all 3 circuit court judges. You know, but it's like they could never behave that way in Sarasota or you know whatever, you know, wherever town they're from. It's like you really gotta, you know, all of a sudden it's like sometimes if you're married or something like that, it's fine. You know, if you got a pretty low-key lifestyle, you know, you certainly can't be a runner. Could be like me. You could be out around 1 o'clock in the morning.
No, that's what that's what I told Kim. I said, well, congratulations, all your fun's over.
Yeah. Yeah.
No more public. But she's, her and I used to, I did drinks with friends. We stayed friends throughout from law school on. So she was kind of how I got to the firm I'm at now. I knew her. She was kind of my connection. So I started fighting trial against them, but she was kind of my end. And then now she's gone. But
Yep.
she pretty much ran full time. And it was a full time job to